Welcome back. You are watching Big Deal and we are discussing the insolvency and bankruptcy law. So Mr. Shroff, coming back to where we left, of course, the entire resolution mechanism has windfall mechanism, and you said that secured, unsecured creditors are going to be at the same keel and they have to work very, very efficiently. Now, we've seen how banks have operated in the last, there are 13 banks in one situation. They all have to be on the same page. How do you deal with issues where there is a defending creditor not consenting to a resolution plan or abstaining from it, and how is the payout mechanism really stated? Is there a dichotomy there, and is that going to lead to some bit of complexity there?
It would lead to a bit of complexity for the simple reason that the Act has now defined the principal majority which causes the resolution to happen. A negative block of 26% or 25 plus 1% could effectively defeat and bring down a whole resolution plan. Because just as you have a positive block, there could be a negative block comprised of financial creditors and secured creditors who don't agree to the process of this thing, in which case also the company would go down the liquidation route. There are a host of legal issues which will arise, and they will have their own complexities to resolve. How do you really go and realize your security if you're not going to be participating in winding up? Do you have to go to the DRT? Do you follow the SURFACE model? So there are a whole set of issues which will require their own compliance, whether you have a 60% majority necessary for going to a SURFACE process. So I'm saying that you've got multiplicity of laws which you will have to then comply with, flowing from the application of the Bankruptcy Act. The whole test is, of course, majority of 75.
But Mr. Shroff, a few things. Information utilities, is there an issue there?
Oh, there's a serious issue there, because the formulation of the current process goes on the basis that the IU is almost redundant. Whereas IU has is a central core of this whole process of time-bound resolution, because the utility information would have been the basis of determining what is the creditor's amount, who are the creditors, who are the operational creditors, what is the extent of their outstanding, and the majority principle which needs to be decided in a resolution plan would have depended upon the documentation or the evidence which is put in place with the IU. If that is not there, there would be a serious gap in determining who constitutes the majority. And therefore, if the resolution plan has to be approved by a majority and you don't have the data to decide how the resolution plan, who are the majority, then you are in serious difficulty of actually knowing what will be the outcome.
Mr. Umerji, you agree that the law may have been notified, the code may have been notified, but the infrastructure is just not ready for it to take off?
As far as information utilities are concerned, it's not yet ready. That's true. It may be that there may be some alternatives which could be used, such as a certificate under Bankers' Books Evidence Act, and there may be an acknowledgement of the debt by the company itself. Normally, companies are required to state, the liabilities in the balance sheet also.
Right.
But here the issue really is of default, and you have to prove a default. And whether default has taken place or not is supposed to be collected information to be recorded by the information utility.
Right.
So that default establishing may pose a problem and a challenge in actually proceeding further with the insolvency proceedings.
Mr. Umerji, one more thing. Have we given enough thought to cross-border insolvency? Is that addressed? Because many experts do suggest that that's not addressed in this particular.
There is a provision made that there can be an agreement entered into with the other country, and in such a case the insolvency proceedings can be conducted in that country, or the assets in that country can be taken over by the insolvency practitioner here. That will depend on the agreement between the two countries.
All right.
But a regular cross-border insolvency law has not been passed.
Yes.
And that's the future agenda where reform which will have to be undertaken.
All right. So hold your thought there, and we will slip into a short breather, but a very, very interesting discussion on insolvency and bankruptcy law, and we'll take it forward on the other side. Stay tuned.